As we continue week 13, we'll look at Chapter 21, Juveniles and Young Offenders. A little history and background. Juveniles in the U.S. criminal justice system are treated under special rules designed for their protection. This can be traced back to English practices. English held that children under the age of 7 were irrefutably presumed to be incapable of having criminal intent. Between the ages of 7 and 14, there was a rebuttable presumption of a lack of criminal intent, and over the age of 14 were presumed to be able to form criminal intent. This could be rebuted by the person and could be they could be prosecuted as an adult. There's also some other English common law concepts. This is the monarch or the government is the protector of the rights and welfare of children. With time, the age of criminal responsibility was raised from 14 to 16, then to 18. In most states, 18 is the age when children are presumed to be adults and are held responsible for their criminal behavior. Other legal concepts that have historically applied to juvenile court proceedings: juveniles are not found guilty of committing crimes. Their act is one of delinquency, a finding is one of delinquency, and instead of sentencing, there's a disposition. A juvenile court sits in protection of the welfare of the juvenile. Juvenile court proceedings are much less formal, often closed to the public to protect the privacy of the juvenile, and a juvenile court sits in the position of a judicial protector or guardian of the rights and best interests of the juvenile. A disposition of the case is based on the concern for the welfare of the juvenile. They're not sentenced to punishment. What is ordered is for the welfare of the child. Cases are handled more quickly than those for adults, and those court proceedings are usually sealed. Juveniles are not sent to prison. If they're placed in institutional care, they're training schools, residential facilities, juvenile homes or similar nature. There is some movement towards more juveniles being handled in the regular adult proceedings. From 72 to 2000, the number of referrals of juveniles to adult or criminal courts increased over 500%. Length of jurisdiction over the case is indeterminate. Courts could be having jurisdiction until a person's 21st birthday, or in some cases later. Commitments to facilities are for shorter periods than for most adults. Juveniles may be committed for an indeterminate time. A release is determined based on the reports of their adjustment and betterment. There's 3 ways in which juveniles are brought before juvenile court. Those charged with act of delinquency, which would be crimes if done by an adult. Status offenders, though, who have violated the societal rules that are not criminal for adults. An example would be a curfew violation. And dependent children, juveniles who have no or deficient family or support. Foster parents or group foster homes may be used. In 1999, over 1.6 million offenses were disposed of by juvenile courts. Most of the offenses were against property. Over 23% of them were female. Over 65% of the petition cases result in the person being adjudicated delinquent, with another 0.8% transferred away to adult court. Probation is the most commonly used sanction, especially for first offenders. Ordinarily, a juvenile refers to persons under the age of 18. As of 1999, in 10 states, it's persons under the age of 17. In 3 states, it is persons under the age of 16. There can be exceptions if there's a finding that the person has sufficient maturity to be tried as an adult. Every state has a means for juveniles to be tried as an adult in criminal court. The traditional way is juvenile court holds a transfer hearing. In 98, 28 states automatically excluded cases from the juvenile system that met specific age and offense criteria. 15 states allow prosecutors to file certain juvenile cases directly in criminal court. In all but 4 states, a juvenile court judge may elect to waive his or her court's original jurisdiction over cases meeting certain criteria and refer those cases directly to the criminal court. For the traditional transfer to adult criminal court, the court hears evidence, reviews reports and recommendations, and considers arguments on whether the juvenile is of such a degree of maturity or sophistication that the case should be heard as an adult. If yes, the judge enters an order waiving the juvenile court's jurisdiction, and the case is transferred to the local court of adult criminal prosecution. In the 80s, there was a public perception that serious juvenile crimes were increasing and the system needed to get tough. In response, many states began to pass more punitive laws. 5 areas of change appeared in the 90s. There was a transfer provision. 45 states passed laws to make it easier to transfer juvenile offenses to the adult court system. Sentencing authority, 31 courts gave criminal and juvenile courts expanded or tougher sentencing options for juveniles. In the area of confidentiality, 47 states modified the laws to make juvenile records and proceedings more open. Victim rights, 22 states expanded the role of victims of juveniles in the juvenile justice process. In the area of correctional programming, due to new transfer and sentencing laws, adult and juvenile correctional administrators developed new programs for juvenile offenders. In addition, some states modified the purpose clauses of the juvenile codes to hold juveniles accountable for criminal behavior, protect the public, recognize and balance the attention given to offenders, victims, and community, impose punishment consistent with the seriousness of the crime, and provide effective deterrence. In Kent v. U.S., 1966 case, the Supreme Court reviewed the rights of juveniles and the constitutional protections to which they're entitled. Kent, at age 16, broke into apartments, stole a wallet, and raped a woman who was there. He was interrogated by police with no counsel present and admitted the offenses and others, and his mother then retained counsel. The juvenile court did not hold a hearing nor talk to Kent, his mother, or his counsel. The court did consider reports submitted by court staff, by social services, and by the probation section. Because Kent was already on probation, Kent's counsel was denied access to the file being reviewed by the judge. The Juvenile Court Act, under which the D.C. juvenile judge was acting, allowed waiver to adult court if the person was at least 16 and charged with offense that would be a felony if done by an adult. It could be done by full investigation by juvenile judge. Kent appealed from the order waiving his case to adult criminal court, and the D.C. court denied his appeal. At trial, Kent was found not guilty by reason of insanity on the rape count. He was found guilty on the other counts, receiving 30 to 90 years. He was mandatorily committed to St. Elizabeth's Hospital for treatment on the basis of the insanity acquittal. Kent again appealed his prosecution in adult court and the convictions. The U.S. Supreme Court held the transfer proceedings were invalid, held that there must be some due process protection. These include the right to a hearing, access by a person's counsel to the reports, a statement of the reasons for the court decision. This was the first time the court set minimum constitutional or due process requirements for juvenile waiver proceedings. In Re Gault, involved a regular juvenile court case. It was not a transfer case as compared to Kent. In Gault, a 15-year-old was taken into custody by a county sheriff without notice to the boy's parents. When he was placed in a detention home, his mother was advised that he was being held for making an obscene phone call. At his juvenile hearing the next day, the petition only said he was a delinquent minor. At the hearing, an officer said Gault, when questioned, admitted to making lewd remarks on the phone. Neither Gault nor his parents were advised of any right to counsel. Gault was committed to the state industrial school for his minority until he was 21. Gault's parents filed a petition for habeas corpus, which was denied in Arizona courts. The U.S. Supreme Court held for the parents, holding that Gault had been denied due process. The court said that delinquency proceedings must also include minimal due process protections, although not as extensive as adult criminal proceedings. These hearings require at a minimum advance written notice, opportunity to be represented by counsel, availability of the privilege against self-incrimination, and absent a valid confession, a determination of delinquency, and an order of commitment must be made on sworn testimony subject to the opportunity for cross-examination. In Re Winship in 1970 dealt with the standard of proof required in juvenile proceedings. In that case, a 12-year-old boy was found to have stolen $112 from a woman's purse. Petition charging the boy with the delinquency alleged that if done by an adult, the crime would be larceny. The governing New York law held that any finding that a juvenile did an act or acts must be proved on preponderance of the evidence. Winship was ordered to be placed in a training school for 18 months, subject to possible annual extensions until his 18th birthday, which was 6 years later. The Supreme Court held that for criminal cases, a guilt finding requires proof beyond a reasonable doubt, a higher standard than preponderance of the evidence. And the court held that juveniles are constitutionally entitled to the higher standard when charged with the equivalent of a criminal law violation. The court rejected the contrary arguments of the New York Court of Appeals that the delinquency adjudication was not a conviction, that the juvenile proceedings were not designed to punish but to save the child, and that to impose a higher standard would risk destruction of the beneficial aspects of the juvenile process. That to allow the child to prevail was probably not in the best interest of the child, and that there were only a tenuous difference between the two standards. On this, the Supreme Court commented that the trial judge had acknowledged that the proof might not meet the higher standard. The court held that the constitutional safeguard of proof beyond a reasonable doubt was required. Boot camps, sometimes called shock incarceration, a special type of sentencing, at times referred to as intermediate sanction or alternative sanctioning. Boot camps emphasize military drill, physical training, hard labor. They're geared to young male offenders sentenced for nonviolent offenses. The earliest currently operated correctional boot camp program was 1984. Stay in boot camps is intended to be short, long and hard daily life, heavily structured, often used for juvenile delinquents, military-style uniforms, pretty regimented. In one sense, boot camps replace specialized treatment for youth offenders. Proponents say that they're cheaper to run, reduce costs, help to reduce crowding in regular prisons. Seen by judges, legislature, media, and the public as tougher treatment offenders, and thus more fitting punishment, help to rehabilitate the offender, deter future crimes. Underlying concept of a boot camp as in earlier specialized programs, concentrating on persons of younger age. They teach respect to authority, self-discipline, self-esteem, good work habits. Evaluation of these arguments for boot camp bring mixed results. Shorter terms, there are overall cost savings, reduces demand for prison beds. There's some rehabilitation, reduction, recidivism. It's not as new as the text may indicate. The text is getting older, so boot camps are pretty much common concept these days. Does the sentencing or opportunity for the program benefits discriminate against women, disabled, older offenders? Those are some of the questions. It is expected that whether a state can justify the distinction and the grounds for discrimination will be explored in further litigation, future litigation. Two, correctional administrators are advised to examine their resources prior to any legal challenges. Examination includes such issues as the number of persons, the programs, and the mix of those who attend boot camp